Immigration policy impacting Canada's growth rate, the construction industry facing challenges with the reduction in temporary foreign workers, IRCC facing reduction of immigration officers by 2,000, interpretation on how designated entities are to transmit the commitment certificate in the SUV program, and changes to the federal court practice on this edition of ImmPulse.
I'm Howard Greenberg.
Hi, I'm Greenberg Hameed.
And welcome to ImmPulse for the week of June 16th. Well, where do you want to start, Numan?
Let's do headline news.
Okay.
Lots of news articles on immigration. The one that grabbed my attention was that the immigration changes on temporary foreign residents and workers has resulted in Canada's lowest growth rate in the last 5 years.
Well, to put it another way, when they turn off the taps, they turned off the taps. When they put these restrictions in place, the numbers dropped quickly.
Right. What do you think is causing the most significant reduction now that we see in numbers from the policy changes that were introduced?
Well, on the temporary resident side, students were number one. I mean, our student population was huge.
Right.
And then our population of spousal workers and workers who received their status through, derivative from the main applicant. Well, they've qualified those, and they don't come anymore, or they don't stay. And then workers are leaving.
Right.
I mean, you're not getting renewed. It's an uphill battle to get LMIAs and to qualify, and so that's all a recipe for a contracting immigration program.
Right. And so I saw, in 2023, there was an upward spike where we hit 700,000 temporary foreign workers. Often, as you mentioned, students that brought their spouses in. We see now that colleges have limitations in terms of getting post-grad work permits, which means spouses are not getting work permits. And we also see generally there's a 16-month rule if you want to bring a spouse in as a temporary foreign worker. So everything's being reduced. The analysts are concerned, though, that we might not have the supply of workers like longer term by making these changes.
Yeah, or the right workers. I
Right.
mean, bodies are not the answer. The skills are the answer.
Right.
And we're really going to have to be very, very careful that we haven't turned the taps off too much, because people are getting turned off of coming to Canada because they don't think they're wanted.
Right. So that's a perfect segue. Turn the page into the next edition of the media. You see the construction industry is concerned that they can't build enough houses for Canadians. Why? Because they can't bring in enough temporary foreign workers, are subject to a cap.
Well, there's no easy solutions to that. There's licensing issues from province to province, which is starting to open now.
Mm-hmm.
And then recruitment is another issue. The Canadian government hasn't been actively involved in recruiting in various countries.
Right.
And so it's up to, I guess, lawyers and consultants and third parties to go out there and beat the bushes to find these
Right.
people.
Interested in your views, there was discussion from the previous minister that there were over 6,000 undocumented construction workers and whether they should be legalized. They're sitting right here in Canada.
Well, my sense is that they are going to be integrated. They're going to stay. But the issue of picking which skills and who is really challenging.
Right. So I think fundamental to our system is making some decisions on which skills stay
Right.
and which ones need to leave if we've got too many people here temporarily.
And you have a relatively new minister
Right.
and a prime minister who's pretty much involved in global issues.
Right.
So all of that may have to wait.
Right. So let me ask you this. The story continues. So IRCC, of all the federal agencies, had the highest reduction of 2,000 immigration officers terminated. How will that work in the context when we have backlogs taking 242 days to even get a work permit extension issued?
I guess the solution has to be AI. I mean, as they develop more sophisticated systems for screening applications and even responding to applications, you probably are not going to need humans if it's an objective system, if it's a system of scoring where it can simply be done
Right.
through technology and evaluated through technology. Humans don't play a part in that.
And so from the perspective of a decision, at what point has an officer relied too much on the AI and not turned their mind to the facts? And there's a tension. At what point you've met your obligations?
Well, we know the courts are supporting the AI so long as the officer made the decision. The real issue is whether the officers saw all the information. Did the AI exclude any valuable information? The officer may very well have seen everything the AI presented, but it might not have been everything that was presented by the applicant.
Right.
So there are challenges ahead.
Right. And in our practice, we've seen when we look at the GCMS notes, often there are concerns in terms of how much individual assessment has been done by the officer as opposed to the system.
And you can see by how they formulated their comments in these notes that it looks like the AI took over and made the assessment. It's just nonsensical. They're not what a reasonable person would put in notes.
So room to go before we can rely on it.
Absolutely.
Let me ask you this question. Smart Borders Act,
Right.
something you've been pretty vocal about.
Right.
If you reduce 2,000 officers and you have backlogs that are through the roof, and there's potentially this new discretion and authority for officers to suspend or cancel applications, is it more likely that they might use some of these powers in a system where there isn't the human capability of processing?
Well, we don't have huge backlogs in the traditional sense in the old days, so they're going to use it surgically. It's quite unclear what the interests of Canada mean as described in the legislation. So we're going to have, or the public interest. So we're going to have to wait and see. The jury's out on this, but there is increased concern amongst lawyers, for example, on what these words mean and how they might use these new rules.
Right. Let's shift over to the SUV program. There was an interesting discussion. We've always debated in the regulation, what is the obligation to transmit the certificate? When a designated entity issues a commitment certificate, they have to transmit it. And sometimes we've seen patterns where the designated entity fails to transmit that certificate, and IRCC has refused the application. What's the interpretation of the obligation for an applicant where that happens?
Well, let's take a step backwards to understand what's really going on here. There's always been a struggle between the regulations, the legislative environment or regime, and the policy regime proposed by the department, which they from time to time update. And in the area of SUVs, for example, and other areas, the regulatory regime is very poor. It doesn't have a lot of detail, criteria, rules of the road, so to speak. And the department's been filling that in with policy. So policy is not law. Law is law and policy is policy. And so in this particular case, you may or may not have mentioned that it's our case, that the certificate wasn't delivered to IRCC before the first permanent resident application was filed. And so the department took the view that it should have been, that's what the policy is, it should have been delivered beforehand. But the reality is, if you read the regulations, there's nowhere in the regulations does it require that. So it's a policy determination that took the place of a legal determination. And the department is now taking the view that that's right. There's going to be new policy guidelines coming out. And so what's really important when applicants and clients come to you is to be able to differentiate between what the law says they should have done and whether it's just simply a matter of policy. And if it's just simply a matter of policy and it's not supported by law, it's open season to challenge those decisions and bring them back.
So if you're an applicant and you're listening to this discussion and that issue occurred, there may be a light or an opportunity.
Well, we know that it's just not resolved in our case. We've been informed that there will be a policy redetermination along the lines of a proper legal process and not just a policy process.
Right. Let's wind up with one piece of good news is I see that LMIA processing for high wage and low wage is down to 50 days compared to 5 to 7 months. So this is firstly a significant turn in terms of better processing. Where you need to be careful though, and we've seen this in several cases, the officers are going directly to the applicant, calling them and asking them questions much earlier in the process about their efforts to recruit, their need for the foreign worker, any attempts to potentially hire Canadians. So that process is going to move faster. Good in terms of if you're well prepared, you get your decision, but you can't assume this will take months and months before you hear from an officer. You can hear very quickly.
Well, I'll tell you what I find interesting about this. If a client was to call you, you would have a predisposition. LMIAs are very difficult to get. The unemployment rate's high. But then we've seen cases where LMIAs were issued, and we say, "What?
Right.
I mean, you didn't have a high level of inquiry. You didn't require full documentation. So how is it that in this case, the LMIA is issued, and in other, maybe even more deserving cases, the documentation request goes on for weeks?"
Right.
So the answer is it's kind of like potluck. I think that the answer in Canadian immigration is you go for it no matter what, because you don't know what the result will be.
Yes.
You can't be sure what the result will be.
Right. Exactly. And for those who are interested in federal court practice, lots of changes in the federal court.
Right. Streamlining.
Right. Representation limited only to lawyers unless you're party to the matter.
Yes.
Right. So again, integrity in terms of the federal court practice. And there's a whole summary in the publication about some of the changes. So
Right. Which makes the federal court process more attractive. The parties may be able to have a case presented where the lawyers do not have to appear in person. It could be adjudicated from documentation, which will speed up the process and eliminate the backlogs. More and more, the federal court is the guardian of the system. Mm-hmm. You must resort to the federal court to get your decision back on track again. You can't just walk away.
Right. Perfect.
Well, what a week.
Yeah. Full week as usual.
I'm Howard Greenberg.
I'm Naman Hameed.
If you need any assistance, or just a phone call, an email, a carrier pigeon away.
Thank you. Thank you very much for joining this edition of ImmPulse. If you have questions about all the policy changes or about the law, please reach out to myself or Howard. We'd be pleased to engage with you. Interpretation, no, it's a construction concern. Okay.
Do you want us all to turn around or something?
No, it's okay. It's good.
We intimidate. Thank you very much for letting us into your homes.
That sounds creepy, man. Especially with that grin on your face.
Yeah, that's great. That better not be a blooper either. I don't want to have trouble. I'm Howard Greenberg.
Hi, I'm Naman Hameed.
Today is another day.